announce that.
Good morning. It's 9 o'clock. This is the 16th of October. Tennessee Auctioneer Commission meeting is 9 a.m. First item this morning is roll call. Clint?
Jeff Morris.
Here.
John Thorpe.
Here.
Adam Lewis.
Here.
Ron Collier. Just let's let the record note that Ron Collier is absent. We do have a physical quorum. For the next item, the notice of meeting. Notice of the October 16, 2017 meeting of the Auctioneer Commission was posted to the Auctioneer Commission's website on October 9th, 2017. As for the agenda, if you guys have an opportunity to review that, if you'll note that we do have a formal hearing scheduled. If at all possible, once the respondent shows up, if we could have the freedom to move that formal hearing to the top of the agenda, and just some freedom within the agenda. And if that pleases the board to do so, if someone could make a motion in that regard, I'd appreciate that.
So moved.
Second.
Mr. Morris moves. Mr. Lewis seconds. Any discussion? All in favor of the agenda say aye.
Aye.
All opposed, nay. Next item.
The next item on your on the agenda there is the minutes. If you can take a look at that, and then let me know if there's any revisions there, additions, or comments that you'd like to make in regard to.
Mr. Chairman, I've reviewed the minutes of the last meeting, and I make the motion that we approve them as written.
Second.
Mr. Morris moves to approve. Lewis seconds. Any discussion on the minutes? All in favor say aye.
Aye.
Any opposed? Next item, education request.
Yes. As you see before you, we have the Nashville Auction School submitting a Tennessee law course, and if you've had an opportunity to review that, we'll of course entertain discussion and motion in that regard as well.
Man, is that a new course, or is that just a continuation of an existing course?
They have some variations of it, is what's talking, but this is a new course.
Course just
Yes, sir.
for law?
That's right. That's correct.
Just a 4-hour law course? Is that what it is?
Yes, sir. That's right.
That's what I took it to be. Well, they have a great record with the TAA and educating auctioneers in the state of Tennessee, so I move that we approve their application for the 4-hour Tennessee law course.
Second.
Mr. Morris moves for approval of the request. Commissioner Lewis seconds. Any discussion? All in favor say aye.
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 Opposed, nay.
We'll go ahead and move to the budget then. We did have the end of the fiscal year budget, and as a result, we have some figures there for review that we'll discuss. We'll start first of all with the last couple of months, and then we'll work our way through the budget at large. I've also put a copy of the operations budget in front of you. On the iPads, that's the Education Recovery Fund, and so that's the difference there. And of course, you'll see at the end too cost backs, and we'll cover all that in a moment as well. We'll start first with the last couple months. The total revenue for the year thus far is $32,085, and then auctioneer expenses are $18,966, leaving us a net surplus of $13,119.
That run or coincide with your anticipated budget?
Yes, sir, it does.
Okay.
It's on track. There's nothing that we've seen as far as that's abnormal. Now, to kind of drill down a little bit further on what all that means, we've discussed it a little bit. Of course, you know what case revenue is. That's what's brought in from whatever is assessed. State reg fee is basically what finance administration charges us to print out the licenses. So Edison expenditures are payroll, some administrative expenses. Administrative cost backs can be somewhat significant, so I want to spend a little bit of time there and just explaining some of that as well. Administrative cost backs include the auctioneer's share of the liquidation of all administrative cost backs from all the programs. The share is determined by licensing count, number of complaints, and budget plan, which accounts for 0.86% for the Auctioneer Commission versus some of our larger programs. For example, Cosmo and Barber, their share is 16% of the cost backs. Because they have near 60,000 licensees, they have more complaints.
Gotcha.
So Auctioneers, we don't have 1%, we're 0.86% of that. If you go to the third page, you'll see the total cost spec, and that was for, let's see, that was for July. If you look for the total cost specs for the fiscal year of 2017, which is the third page, that's tracking about average, because the percentage there was 0.82%.
Right.
So that's what you're looking at. And if you look at the total budget, for example, total administrative cost specs were $3.2 million for all of our programs, and then the share of the auctioneers was $26,000. But of course, that makes sense if you're.
We barely show up.
So when you're looking at
I see that.
Right. And you'll notice that too. Administrative cost specs are, if you get a look at that, if you look at the operations budget that you have before you, the handout that I laid before you, you have things like, equipment, inventory, land, buildings. One item of note that's kind of a significant expense is the state professional services budget code. It's 725. It's at the very bottom of total other expenditures. And if you notice, that total is typically larger than the others. And what you're looking at there is rent. The space that you rent, the fax lines, phones, things of that nature. Questions as regard to that? Or? All right.
My main thing, I like to focus on, make sure we have our reserve where we need it to be, and that we're not ever out of compliance for that.
And that's the beauty of doing the trending, because then you can track it. You're not surprised. And so, and before we go to our board meetings, I always review these, and if I see a number that looks strange to me, I always talk to our accounting director about that.
You know when the bulk of the licenses are renewed?
They're not on they are on a 2-year renewal cycle, but that's sporadic. It's not like, it's not like there's one quarter that's quite a significantly larger than the other. It's not like some other
It's
programs.
specific to them, not like
That's correct.
I know some states, it's all comes in October or September or November or whatever.
That's right. Like our land surveyors, they're all doing their 2-year renewal right now.
Right.
To the end of the year.
Okay.
Is there any other questions that you folks had on that?
Action from the board?
No, sir. Just if I may, I'd like to update the board on a couple items that we've discussed before. The first one, and Ronnie's he's not here, will not have the immediate benefit of it, but hopefully he's watching or can review this, and we'll discuss with him as well. But he brought up the renewals. His question about the renewals was he said that himself and some others had difficulty or hadn't received it when they had expected. So we looked into that and talked to IT about that. And Core has had some issues with renewals printing with incorrect fields and therefore not reaching folks. They've made the necessary updates. Apparently, sometimes anomalies will relapse, and then once those are brought to our attention, we'll go back and correct those as well. We do try to get those renewals out the best we can, but of course we have to depend on the information provided as well. And just last week alone, I was talking to our administrative manager following up on the issue, and he said he received several renewal, that there were several folks that called about renewal letters, and in both cases, they changed their addresses a year ago, and as a result, failed to update our office. So that's a lot of it too. That's not all of it. That's not Ronnie's situation,
right,
obviously, and that was being addressed with the core issues. Ultimately, we don't have we try to do that as a courtesy to make sure we keep up with that the best we can. But
Y'all do email notifications at all?
we'll do general email blast when there's some updates legislative.
But you don't do specific renewal emails to licensees? Okay.
We're always looking to automate things the best we can. Some of the letters will still go out, and so that's something we've depended on. But we're always looking to consider options like that. Of course, then we run into some of the same problems as well, when it comes to updating. That was the update on the renewals. There was one issue regarding newsletters as well. Basically, we were looking at that. We talked to Ms. Hanson, and she had the last, I guess, contract on that. So we were discussing that with her. Right now, the executive management stance is that we're looking at the recovery fund, and we'll update on that, whether or not that's something that will continue. But just the kind of the short of the long is there's not the mandate to do that, to give industry updates. And so that's typically best left with the association. And so that's something that at this point we weren't going to consider continuing. However, we'll continue looking at that recovery fund and deciding from there if that'll be something going forward. And I'll give you the updates on that once. Right now, without the mandate, there's not the pressing urge to do that.
Well, what we might do is we might talk to the association and find out if they're getting any feedback at all from their members as to whether they are wanting a newsletter, which they had a newsletter, if the association is going to do a newsletter. There is kind of a lot of stuff going on in the industry right now that we need to make sure everybody's up to speed on. And I know most other states do it. I get them from Mississippi and Alabama and from Arkansas. Arkansas does a really good job with their newsletter, but they've got a more active association, it seems like. But anyway, we just need to, I don't want it to go off the radar screen. I want us to kind of keep an eye on that and make sure that we're at least listening and seeing if the members want that.
You know, they do pay into that recovery fund, so that's why we're looking at that recovery fund. So we want to be sensitive to that. We just want to make sure that, and like you said, you make a great point. If there was a feel that the licensees were wanting that, and we could somehow measurably quantify that, I think that would be really helpful.
Okay.
So we may just have to explore some ways to tap into that and get.
You might look into, listen to some of the Middle Tennessee guys and see what they think.
I get one from Alabama as well. They're extremely helpful. We do need one. And the recovery fund is, I got a copy of the audit that was sent out. Are they looking at doing away with that?
Don't change the law.
Please.
Hey, I think I've met all y'all before, but Assistant Commissioner Carter Lawrence. So the comptroller's audit, looking at the when they and another, their focus wasn't explicitly on doing away with it. I do think that is something that the General Assembly would be interested in if they start to take notice of the fund. That would be something that they would be interested in. I'm sure y'all are all aware of sweeps that have happened in the past related to the regulatory boards, and that's something that we're trying to keep in mind as we look forward to what might happen with this fund. So you might have seen that they had a recommendation about making it more visible for the consumers. So that is something that we've done already, and we're going to ask staff to, in presentations to the public, to give the information about how one can go about accessing that fund. So we're trying to be proactive and get ahead before the General Assembly might look at going in and sweeping these monies.
Are there any directions on the website for consumers if they wanted to take action or in the complaint area about the steps they have to go through in order to make access to that fund?
That is what we added.
Okay.
Yeah. It was lacking, but we've put that up.
I noticed
so
it wasn't there when I
consumers
was
can see it.
looking through it at one time. So.
Mm-hmm.
Else, Glenn?
Looks like we're ready for the legal report. There's no action on the director's report in that regard, so we can move on to the next item. If we can, let's just address in the interest of respecting the judge and the court reporter's time, if we can address the formal hearing. We don't see the response this time.
Somebody check and make sure he hasn't checked in with the security, since I don't think he'd be in the room next door, since it looked like I have had them sitting in the wrong hearing room before.
I have as well, Your Honor. In the meantime,
Yeah, I'll give them the introductory part. Members of the board, today is, October the 16th of 2017, and we are present in Nashville, Tennessee for a hearing before the Tennessee Auctioneer Commission. The case that you all have today that Ms. Ryan is handing out the notice of hearing and charges for is the matter of the Tennessee Department of Commerce and Insurance versus Jeremiah Tothero. Is that how you pronounce it?
I believe so.
and Jeremiah Tothero, DBA Jasper Trading House and Auction. The docket number in my office is 12.15-146605A, and there are 3 case numbers within the department that are listed there on the notice of hearing and charges as well. I am Mary Collier, the administrative judge assigned by the Secretary of State Administrative Procedures Division to preside over this hearing, sitting with the board. And if we could, for the purposes of the hearing record, I'd like to have the board members please introduce yourselves at this time.
I'm Jeff Morris.
John Thorpe.
Adam Lewis.
Thank you. And Chairman Morris, do we have a quorum?
Chairman Ford.
Chairman
We
Thorpe?
do.
We have
Yes,
a-
we do, Your Honor.
Thank you. Today, I will make all rulings regarding the order of proceedings, the admissibility of evidence, and any procedural questions of law pursuant to the authority granted to me by the Tennessee Administrative Procedures Act. I will not participate in the findings of fact, the conclusions of law, or the ultimate decision of the commission. Those decisions will be made by the commission members. I have got 4 other, or it looks like 3 other documents. I'll identify Ms. Ryan. Let me make sure I have everything you filed. There is that original notice of hearing and charges that was filed on August the 17th of this year. The pre-hearing order I issued on September the 18th, setting forth, similar to the notice of hearings, today's hearing date, time, and location, as well as pre-hearing deadlines in my office. The state then filed on October the 3rd of 2017 the witness and exhibit list for the state, and on October the 4th a notice of appearance via affidavit. I did not receive anything from the respondent. Did you?
No, Your Honor.
Okay. And go ahead, if you would, introduce yourself for the record. I know
Yes.
everyone knows you.
That's okay. I'm Robin Ryan with the State of Tennessee.
Okay, with regard to that 4th document, Ms. Ryan, the affidavit referred to attachments that were not filed in my office.
You didn't get those? I apologize, Your Honor.
That's okay. I got the affidavit, just not the attachment. Well, when we get to that, as long as, I just want to make sure you have a complete copy today in case we need to go find that.
I do.
All right, members of the commission, during the time the hearing is being conducted, there should be no discussion concerning this case among commission members, myself, witnesses, attorneys, or board or commission staff outside of the hearing itself. All discussion should be made here on the record. During the hearing, the commission sits like a jury and must only consider the evidence admitted during the hearing itself in reaching your decision. The Tennessee Open Meetings Act or Sunshine Law requires that all commission discussions and deliberations be in public before all parties that are present for the hearing. Failure to comply with the Tennessee Open Meetings Act could result in the commission's action being reversed or remanded if the case is appealed to Chancery Court. During any breaks that we take, please do not use any electronic devices such as your iPads or phones or anything like that, laptops, to research anything related to the case. Instead, we would like for you to consider only the evidence that is presented here during the hearing itself. You should not draw any conclusions until all of the proof has been submitted, and you should listen openly to all of the proof regardless of which side submits it. Did we have a chance to check to see if Mr. Tothero was outside?
We did. Our paralegal went to check, and he did not sign in. He was not there.
Right. Do you have a motion for default?
I do, Your Honor. I move for default, and based on that default, I would tell the court that this matter was filed on August 17th, sent by certified mail to the address we had in Tennessee, but that mail was returned. On August 29th, we put in a request for personal service by an investigator, and Timothy Connors went to the address we had, which was 715 Red Bard Road in Grutelli Lager, Tennessee, and the respondent was not there, but filed an alternative address at 13620 Tennessee Highway 28, Whitwell, where he found the respondent. The investigator then served the notice of hearing on the respondent and secured the respondent's signature to the receipt of that notice of hearing. I will also tell the court that on September 20th, Mr. Tothero called our office and first spoke with our paralegal, Rihanna Womack, about this matter, and then I returned his call. And in our conversation, he told me he would be here. I would like to enter, Your Honor, this affidavit as well as the signed document by the respondent as proof of our service. For the court as well.
What was the new address you found?
The new address was 13620 Tennessee 28 Whitwell.
That's the affidavit you've given notice of, and it has the attachment to it.
That's correct.
All
That's
right.
where he was served.
If you would pass a copy to the court reporter, that will be marked and entered into evidence as Exhibit Number 1, and you may also pass copies to the board.
After review of this, Your Honor, we do ask that you find that the defendant is in fault and allow me to go forward on a default judgment.
So the address that's on the personal receipt, is that where he was, or was that a different
The address on the personal receipt is his address. The address where he was served, though, is the address he was served at in the affidavit. This is his address in the receipt. That's his physical address. He was at another location on the day in question.
Well, the address in the affidavit is the 715 Red Bard Road.
That's where they drove to, but that is his address, Your Honor. And then where he found him that day operating a forklift was at this other address. Found him at that address.
Is it Barn or Bard Road?
I think it's Bard, B-A-R-D. I'm not sure.
Got Barn on one page and Bard on the other.
I'm not sure. Is it- Paralegal says it is Barn Road.
So the second, that means the address on the personal service receipt is correct for the address, but he was actually located at this other address in Whitwell
That's correct.
on the forklift.
That's correct.
Okay. Thank you. And your office has spoken with him about today's hearing date as well?
I personally spoke with him.
All right. Members of the board, based upon the personal service of having tracked the states having sent a representative who tracked Mr. Tothero down individually and served him with a copy of the notice of hearing, his discussion with Ms. Ryan about today's hearing date, time, the fact that in addition to the notice of hearing, he also received the order that my office sent to him at his mailing address, which is that 715 Red Barn Road address. That's not been returned to my office. I find that the service of notice in this case of today's hearing, date, time, and location is sufficient and proper. Default is proper when a party fails to attend or participate in a pre-hearing conference, hearing, or other stage of a contested case. At this time, I will turn over the state's motion for default to the Commission for a determination as to whether or not you would like to hold the respondent in default. In making this determination, you will need to consider the statutory definition of default, which is found in Tennessee Code Section 4-5-309A. Therein, the code defines default as follows. If a party fails to attend or participate in a pre-hearing conference, hearing, or other stage of a contested case, the administrative judge or hearing officer hearing the case alone, or agency sitting with the administrative judge or hearing officer may hold the party in default and either adjourn the proceedings or conduct them without the participation of that party, having due regard for the interests of justice and the orderly and prompt conduct of the proceedings. Mr. Chairman, I'll turn it over to you to preside over the Commission's deliberations on the state's motion for default.
Thank you, Your Honor. What is the will of the Commission?
I would make the motion based on the evidence given that we do find the defendant or grant the default judgment for the plaintiff in this case.
Commissioner Morris moves, grant the default judgment. Commissioner Lewis seconds. Any discussion? All those in favor say aye.
Aye.
All opposed, nay. Let the record show all three members present voted in favor.
Mr. Chairman, do you all wish to proceed with the case as an uncontested case?
Yes, Your Honor.
Brian, would you like to make an opening statement?
Yes, but before we go further, I would like to make two corrections in the notice of hearing and charges. One is an error under factual allegations complaint. It says 2915. We're not there yet. It's 2015 on the bottom of the first page. And then we did not catch this either up above in paragraph 2. It says respondent associated trustees. It should be respondent Jasper Trading House and Auction Company, and it is likewise Jasper Trading House throughout the rest of the document. But I wanted to bring that attention and correct it in the notice of hearing and charges at this point.
So in paragraph 2, scratch out the two words that says Associated Trustees LLC.
And it should be Jasper Trading House and Auction.
Jasper Trading House and Auction.
And underneath that, under factual allegation, the first complaint, it should be 2015, not 2915.
What paragraph is that?
That's the complaint number.
Yes, that's the complaint number. Under factual allegations, complaint number.
2015,
Yeah,
not
not
2915, okay. 2015-022-80861, right?
We are not back from the future, so. Issues today, Commission, is that of unlicensed practice as an auctioneer. You will learn that these respondents, Jasper Trading House Company, known as Jasper Trading House and Auction, Jasper Trading House Company, and Jeremiah Tothero were operating as an auctioneer and an auctioneer gallery firm, and as an auctioneer personally, and that Mr. Tothero admitted to an investigator that he personally did at least one auction. You will hear there was no firm or gallery license, nor any license from Mr. Tothero for either him individually or for the business. There were several investigations in this matter, and advertisements for auctions on Facebook as well as that statement, as I just suggested, to our investigator. He did hire a licensee for most auctions, but Jasper Trading House has never been licensed, nor were the auctions taking place at a licensed location. Proof will show that this started from an investigation in 2015 against another potential person doing unlicensed activity, and then the investigation revealed the activities of these respondents. Complaints were then opened. There were 3 of them, and respondents were investigated again and found supporting proof that indeed these respondents were holding auctions with no license. In 2016, the investigator again found that respondent had a business license and a new and different address, and that auctions were taking place at that address as advertised on the Facebook page. As you as the Commission know, the laws of Tennessee require that an individual cannot act or advertise as an auctioneer without a license, and the laws also require a gallery license for operations of any auction. These laws are in place to protect the public from illegal and unscrupulous behavior. In this particular instance, we don't know the whole set of facts. We will find out that Mr. Tothero has been not exactly forthcoming in working with us. He is not here today, but we believe at the end of the whole hearing you will find that he had, at least on 3 different occasions, auctions, he individually and or he as Jasper Trading House, and that we should assess a civil penalty for trying to pay all the cost of this matter. Thank you.
Thank you, Ms. Ryan. Who would the state like to call as the first witness?
Check. He was reminding me of his last name. Thank you.
How do we spell his last name?
Opchak.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you. Please state your full name for the record and spell your last name for the court reporter.
Glenn Kopchak, that's Kopchak.
Thank you.
Yes, ma'am.
Go ahead, Ms. Ryan.
Thank you. Your position with the state of Tennessee?
It's Assistant Director over Centralized Boards.
And how long have you had that position?
My year anniversary for this position will be January 4.
And in the Assistant Director, are you also considered the Acting Director of the Auctioneer Commission?
Ma'am.
So does that mean that you are in charge and you lead the meetings as you did today?
Ma'am.
Does that mean also that you work directly under the Executive Director? And
That's correct.
And you're her appointed delegate?
That's right.
And is the program considered the keeper of the records for auctioneers?
Yes.
And therefore, are you then the person that would oversee and look at the licenses and complaints for various parties?
Yes, ma'am.
Have you reviewed the complaint files of Jeremiah Tothero and Jasper Trading Company?
Yes, ma'am.
How many complaints were open against these respondents?
There was 3.
Why were there 2 complaints against Jeremiah Tothero and only 1 against Jasper Trading Company, if you know?
I would surmise, and I don't want to get in the business of surmising, but there was 2 accounts of investigations going on due to tips, and as a result of those, it was discovered that there was a business license associated with Jasper Auction Company, and then there was Facebook pages directing folks to, according to the investigation reports, to that location. So hence the complaint coming on Jasper Auction House on that one, and then 2 for the respondent.
When were the first set of complaints opened?
The first set of complaints was opened August 28, 2015, and then the second one was opened August 10th, 2016.
And the reasons for the opening of these complaints?
Both of them started, the short and the long were informants, and then administrative complaints were opened as a result of that. Investigator was sent, and of course we'll hear from the investigator, I imagine, later on based on these reports, but investigator was sent to investigate that, or was referred from as a result of those informants to the investigator, and then out of that we have the factual findings that will be presented today.
And in the complaint files, did you investigate whether or not Jeremiah Tothero had a license?
He did not have a license.
How about Jasper Trading House?
It did not either. They had a business license, but did not have a firm or gallery license.
And do your records reflect either one of them ever applied for a license?
We don't have any records of open applications that would show that, no.
So as far as our state records show, whatever business license they had, they never held an auctioneer license under the auctioneer.
That's correct.
What is the complaint process?
Typically, they can come in, and that can be generated through a couple avenues. One is just folks will call the complaint line and then inform on potential situations that may be needing an investigation. Sometimes those complaints are anonymous, and there's not much offered for us to follow on, so that then they won't get referred, and they'll die right there, unfortunately. But if there's something substantive that that tangible that can be followed up on, the person isn't anonymous, so we can follow up and get more information from an individual. Typically, it'll be referred to legal, and then legal, depending on the complexity of the case or whatever the scenario is, they have the opportunity to assign investigators as well to that. And in this case, there was one informant that was working with legal on the latter complaint, 2016. There was another informant that basically gave a tip, which was referred to legal, and then the investigation was open.
And after an investigation open, what happens? Is it presented? Does it die? I mean, what does legal do with it?
Legal will investigate the and try to either disprove or substantiate the claim. They just follow the trail wherever that leads. If that leads to what appears to be unlicensed activity in this case, then there's an effort made to the respondent to allow them the opportunity to settle, and then if they're in disagreement with that, then it can be referred to a formal hearing, is what we're doing here today.
And the opportunity to settle, is that something that is presented anonymously to the commission initially for their review as well?
That's correct. These will come before the board as well in our legal report. We'll have the legal report later on, but we'll bring that announcement before the commission, and the commission will review the facts presented anonymously as suggested, and then we'll render a judgment, or sometimes we'll dismiss it. That happens as well. But in this case, a judgment was rendered and then offered to him in an agreed citation.
So Mr. Tothero and Jasper Trading House had an opportunity to address the situation through a
That's correct, yes.
What are the laws in Tennessee concerning when a person must be licensed as an auctioneer?
TCA 62-19-102 says it is unlawful for any person to act as or advertise or represent to be an auctioneer, apprentice auctioneer, or firm without holding a valid license issued by the commission under this chapter or prior state law. So if they are in the I guess in the act of auctioneering as defined by statute, then they have to have a license to do that.
And it appears that even if they advertise there's going to be an auction in their name, they also have to have a license?
It does state, let me get back there, act as or advertise or represent to be an auctioneer, apprentice auctioneer firm.
So then if I were to say, I, Robin Ryan, are auctioning off property, I would have to have a license. If I put an advertisement on my Facebook, say I'm on auction off all this property.
It's assumed that if you're advertising an event, that there's an event happening.
Are there exceptions to the rules and laws?
If you own the property, that's one exception. But yeah, the exceptions do exist.
So if I own the property I'm advertising, or if he had owned the property, somehow that if we'd known that, then he wouldn't necessarily be required.
That's correct.
And are there other exceptions? That is, if does a trustee or a receivership have to have an auctioneer license?
So someone representing the court, in that regard, would not need an auctioneer license as well.
What about a firm license? What's the laws concerning that?
If I may, I'll just cover both statutes. The first was the exceptions. 62-19-103 states, any person acting as a receiver, trustee, in bankruptcy, guardian, administrator, executive, or other such person acting under order of any court. And paragraph 5, any person performing acts in the regular course of or as an incident to the management of an investment in property owned or leased by the person if the property was not acquired for the purpose of resale.
Oh, so if I acquired the property for the purpose of reselling it, I'd still have to have a license?
That is what that implies. Right.
Okay. How about, again, what?
I'm sorry, and then the law concerning a license of a company or firm, that's 62-19-125. That states, any person who desires to own and operate an auction house, auction barn, auction gallery, or any other type of auction operating at a fixed site for the purpose of selling consigned or purchased goods at a fixed location is required to first obtain a gallery license.
So what if the person who owns the company, and the company does the auction on the company name, would the company then need the license?
Whoever's conducting that auction.
So if the company had it advertised the company's name, like, for instance, Jasper Trading House, the company would need the license?
That's correct. It's a fixed site, and if they're conducting an auction, it would need a firm or gallery license.
And if an individual bought a bunch of stuff, but had the company doing the auction, even though it was individual stuff, that company would still...
That company is subject to a license, that's correct.
Looking at 2015, 0220861, which is the complaint against Jeremiah Tothborough, that complaint was opened, and it was opened based on an investigation, is that correct?
It started with an investigation elsewhere, but then by affiliation, Mr. Tothero's name was affiliated, and then so the investigation expanded out to include Mr. Tothero.
Well, what was discovered that in that investigation that led to this complaint?
There was advertisements for auctions to Jasper Trading, and Facebook ads, things of that nature, directing folks to that site. Then there's investigations. We'll get into all that. Having not conducted the investigation, I won't be able to provide all the nuances. I can read the record, but basically, in follow-up, it was assessed that auctions were taking place at that location. There's a affiance that made the statement that he did in fact conduct auctions as well.
Now, was a complaint also opened against not just Mr. Tothero, but at the Jasper Trading House based on the same investigation?
That's correct on it. That's right.
Now, having said that, we're going to be passing out documents, and the number on the complaint number for the Jasper Trading House is not going to be the same number as here today. Can you explain that to us?
That's correct. That's an error in it's administrative error. There's the ones that should be listed. The case numbers are 2015 0220861 and 2015-0220-921.
And those were both initially based on the 2015 complaint, is that correct?
That's correct.
And there were follow-up investigations as well?
That's correct.
Okay.
That's correct.
Is there another, 2016 complaint?
There is 2016-055781.
And what was the reason for that complaint being opened?
That was also a tip. Basically, there was more advertisement in that regard. That was, and having already investigated once and realizing that there was a trend there, follow-up was made, which resulted in the second complaint.
Has Mr. Tothero ever contacted the department concerning these matters?
We don't have record of it. The contact that we have recorded, obviously, is the service of for the formal hearing, and then I imagine, based on testimony as well, he's contacted legal. This is, stating that he's been aware, but as stated before. But to us, administratively, there's no record that there was any contact for.
So he never tried to remedy the situation or attempt to get a license or attempt to explain anything with the department at all?
There's no record of it, no.
What are the civil penalties provided by law for unlicensed practice as an auctioneer and as an auctioneer firm?
TCA 62-19-126, paragraph 3 states, each citation shall contain an order to cease all violations of this chapter and an assessment of a civil penalty in amount of not less than $50 and no more than $2,500 for each violation. After all administrative appeals have been exhausted under Part G of that, the administrative director may apply to the appropriate court for judgment in amount of a civil penalty plus applicable court costs in order to cease activities and violations of this chapter.
Yes. While you're organizing that, Ms. Ryan, Mr. Do you have a copy of the notice of hearing?
I have a copy of it right here, yes, ma'am.
So, based on what Ms. Ryan said at the beginning and then on your testimony, if you look at the top section of that document, the first number and the third number are correct numbers, but there's a typo in the second number.
That one, you're right, that one's interposed. That would be 2015-0220-921, not 210.
And then at the bottom of the page, that should be 2015, and then the number at the bottom of page 2 and the middle of page 3 are correct, right?
That's correct, yes, Your Honor.
Okay, thank you. Did y'all get that, members of the board? All right, go ahead, Ms. Ryan.
I'm going to ask you to see if you can identify.
Is the question, have I seen these?
Are these the complaints you were speaking of earlier?
Yes,
Complaints that were
yes,
said?
yes, ma'am.
Okay. Your Honor, I would like to enter these in the exhibit and pass them to the committee.
Got 3?
I've got 3 separate complaints. I've got copies for everyone, including you.
Okay. If you'll let me see them, I'll tell you what we'll number them as.
They can be collected in the citizen's report, please.
I'd rather do 3,
That's fine.
since we've got the confusion with the number. Okay. Which one do y'all want to talk about first?
Well, we've talked about all 3 of them. I'm entering them right now as evidence, as supporting evidence.
Okay. One that is for number 2015-02286. So that's, oh, we got to go back then. Notice of charges, so that first number at the top's not right either, correct?
Your Honor, on the Jasper Trading House Company, that number on the new matter transmittal is incorrect on the Jasper Trading House Company. For Jasper Trading House Company, the number should be 2015-022-0921 on the Jasper Trading House. On the 2015 complaint against Mr. Totherow, the number should be 2015-022-0861. The number for 2016 is 2016-055781.
So there's not one that's 2015-022-0921?
Yes, there is.
Which one is that one?
That, I believe, is the Jasper Trading House.
Jasper Trading House Company is that one, Your Honor. 2015-022-0921, not the number that's on the new matter transmittal.
I see what you're saying.
On new matter transmittal, they have a wrong number on it.
Okay, well, why don't we have Mr. Kopchak write the correct number on the one that's going to be the real exhibit? Because that number doesn't match anything.
Correct, it does not.
Go ahead and testify as to what you wrote on there, so we'll know.
Yes, it's 2015-022-0921.
All right, and that is that packet, members of the board, will be marked and entered into evidence as exhibit number 2. I will hand that to the court reporter. She'll get that marked. Pass copies of that to the board. Members of the board, you may want to make that correction in case you have questions for Mr. Kopchak about it. It'd be easier to refer to the correct number. Do you have a copy? You can have that copy. All right, and then the one that is for number 2015-022-086, is there a 1 at the end of that or not?
There is a 1 at the end of that,
There
but
is a
that's
1?
that's yes and no, yes.
Okay, so if you'll add the 1 on that one. We'll pass this one down to the court reporter. That'll be exhibit marked and entered as exhibit number 3. Pass copies to the board. And then, is there a 1 on the end of this next one too? The 2006-05578? I'll
Yes,
add a
Your
1 to that one. And it will be marked and entered into evidence as exhibit number 4. Pass copies to the board. If you'll hand this one to the court reporter, please.
I have nothing further for this witness, Your Honor.
Members of the commission, you all have been handed exhibits that are marked and entered into exhibits number 1. I'm sorry, number 1 was proof of service. Exhibits 2, 3, and 4. I'll give you a minute to review those, and then in addition to having a chance to review those exhibits, it is also your opportunity at this time to ask Mr. Kopchak any questions that you all have. Yes, go ahead.
Have you spoken to either one of the defendants, either one of the Tothros or Eric Meeks or anybody with regard to this case?
As administration, I haven't spoken with either one of those. Investigations has made contact with the individuals.
Right.
And we'll, I'm sure.
Now, we took this case up and we submitted a consent order for them to sign and send back. Is that correct?
That's correct, yes, sir.
Did they respond to that consent order?
Not to,
Your Honor, if I might, if it's all right.
Go ahead, Ms. Ryan.
The issue of the consent order responding to it would then be for communication.
Okay.
And their interest in whether or not they would want to settle is not an issue before the panel.
I'm just curious.
Other questions for Mr. Kopchak?
None from me, Your Honor.
All right, Ms. Ryan, any other questions for Mr. Kopchak?
No, Your Honor.
Thank you, Mr. Kopchak. Who would the state like to call as the next witness?
Lori Wilson Weaver.
Raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you. Please state your full name for the record and have.
Wilson Weaver.
Thank you, Ms. Weaver.
And Ms. Weaver, what is your position with the state of Tennessee?
Regulatory Board investigator,
And how long have you held that position?
about 16 years.
And what are your responsibilities as an investigator?
Conduct investigations of licensees or unlicensed practice assigned from boards and commissions to the investigations division.
So as an investigator, are you then familiar with, or did you investigate Jeremiah Tothero and Jasper Trading Company? When did you initially investigate this matter?
Initial investigation was assigned in August of 2015.
And was that against these two parties?
It was initially styled against Eric Meeks.
And how in your discovery and investigated Eric Meeks did you come to investigate Jeremiah Tothero and Jasper Trading Company?
I initiated the investigation. I went to the city of Tullahoma. It was reported by the complainant that Meeks had advertised a auction to be conducted at 1214 South Main Street in Tullahoma. And I went to that location, found the building locked, and identified a for sale sign on the building. And I contacted the real estate agent, Mildred Walker with Weichert Real Estate in Tullahoma, to determine any information that she might have about Eric Meeks or the operation of the location as a auction site.
What did you discover from her?
At that time, I initially just spoke with her, and she identified Jeremiah Tothero as the person who initially approached her with an offer to lease or purchase that building for the purposes of operating a auction house at that location.
And what happened?
And that's where I first came across the name Jeremiah Tothero. I looked for Eric Meeks in the Tullahoma area. I spoke with law enforcement sources in the Tullahoma area, and Eric Meeks, the only issue with him that I found is that Ms. Walker identified him as an associate of Tothero's, and he was at a meeting between the owner of the property, Ms. Walker, and Tothero and this Eric Meeks. I did find a Facebook page for Meeks, but there was literally no information on that Facebook page.
Did you find Facebook pages for Jasper Trading House in this investigation?
Eventually, yes.
Did you also talk with the property owner of this particular property in Tullahoma?
I did.
And what did you learn from the property owner?
I spoke with Steve Smith, who's the property owner, and he essentially confirmed what Ms. Walker said, that he had spoken with Jeremiah Tothero about leasing or buying the property. He alleged that he wanted to gauge the success of the auction, initially just let him lease or use the property for a period of time before he committed to buying the property.
Were there auctions that took place at that property?
I know of one auction that took place
By these respondents? That
by
is-
Tothero, and I could never connect Meeks to the actual auction.
But at least Tothero and...
Jeremiah Tothero operated the auction. Steve Smith gave him a key to the property on a preliminary agreement to either lease or buy the property.
And so there was at least one auction took place at the
At least one
Tullahoma.
auction, correct.
Okay. Did you determine any, in this investigation, did you determine any other locations for any other potential auctions?
I did through a series of inquiries. I did a background investigation on Meeks or on Tothero to find any addresses or any other information on Mr. Tothero to better locate him. I found out that he had a residence address at the 715 Red Barn Road in Grootly Lager, and went to Grundy County. This is in Grundy County, and spoke with some law enforcement sources about him, about where he lived, if they had contact with him as a complainant, respondent, victim, witness in any proceedings in Grundy County. I also spoke with Sergeant Meeks with the Grundy County Sheriff's Department, And she provided me with some information, one, that Jeremiah Tetherow was operating Jasper Trading. And she gave me the name of an individual, Misty Meeks, who she relayed to me was an employee for a time at Jasper Trading.
Did you speak with Misty Meeks?
I did.
And what did you learn from Misty Meeks?
I spoke with her and obtained her affidavit also. She told me that she had worked for, she knew him as Capon Tetherow. That's his middle, and he uses that as an alias quite a bit, but it's Jeremiah Capon Tetherow. His wife is Felicia Tetherow, and basically they operated this Jasper auction house and trading company at 12. The exact address, but it's on Main Street in Jasper, Tennessee. It's a storefront building there next to the O'Reilly Auto Parts. Ms.
How do you spell Capon?
K-A-P-E-N.
Thank you, go ahead.
Ms. Meeks advised me that she'd worked there for several auctions and that her responsibility was, once an item was sold, that she put the bidder's numbers on it and removed it from the floor for the next item to come up. And she indicated that if the items didn't sell at auction, that they kept the place open and kind of yard sale stuff also out of there.
So she did say and affirm that were auctions taking place at the Jasper, Tennessee location site.
That auctions were taking place and that she worked for
And she was there
Jeremiah
for when the auctions were taking
and
place.
Felicia Tetherow.
And did she indicate that there was anybody conducting the auctions in her affidavit to you?
She said there were several auctions conducted by Brent Meyer.
And who is Brent Meyer?
Brent Meyer is a licensed auctioneer.
Did you speak with Mr. Meyer?
I did.
And what did you learn from Mr. Meyer?
Mr. Meyer advised me that he did call several auctions at that location, but there were some problems that came up with his understanding of whether or not there was a gallery license at that location, but became really upset with Mr. Tetherow and quit auctioning.
Now, in this 2015 initial investigation, you said you did later find and you included some advertisements on Facebook by Jasper Trading?
There are Facebook advertisements for
And you
Jasper.
included that in your investigation?
That's correct.
And you also included Mr. Meyer's affidavit in that investigation, the 2015 investigation? And Misty Meeks' investigation?
Ms. Meeks also, yes.
Did you, after this 2015 investigation, did you have an occasion to do an additional investigation?
I did.
And when was that?
I believe that one was in February of 2016.
And what did you learn in that investigation?
All these out. Again, it was with regards to Jeremiah.
Did you go to any different
Tetherow.
location in 2016?
I also looked at a site in Kimball, Tennessee that they'd operated for a while.
Did you go to any place like a Dunlap site?
And that was a little later on.
Well, that was 2016, was it not?
Right.
Okay.
I did an interview of another individual who had been identified as providing sound equipment for the Jasper, Chris Gully. And when I interviewed Mr. Gully, Meeks had also said something about Chris Gully possibly calling auctions for Tetherow at the Jasper site. I located Chris Gully in Bridgeport, Alabama. And I interviewed him about the Jasper site, and he indicated to me that the only thing that he did was provide sound equipment. And in the course of interviewing him, he said, oh, by the way, Mr. Tetherow has opened a new location on Highway 28 in Dunlap.
Did you go to that location?
I went by, I was in Chattanooga on business and came back to Nashville by that location.
And what did you find?
And it was on a Saturday night. When I went by the location, there were vehicles parked in the parking lot. There was a sign posted for auction under DGB liquidations. I could hear an auction being held. I didn't go in or anything, but you can hear the calling of the bids and everything.
And was this the same, it's not Jasper Trading House though, right?
No, this is DGB liquidations.
And what did you learn about DGB liquidations?
That's, Chris Gully said he's got a new auction place, and it's called DGB liquidations.
Did you investigate further, find out if indeed this was Jeremiah Totherow?
I did.
Okay, and was indeed the Jeremiah Totherow matter?
I went to the county clerk's office in Dunlap, Sequatchie County, and obtained a copy of a business license for Jeremiah Totherow at that Highway 28 location.
And that you found in this, in 2016, is that correct?
That's correct.
And did you do a follow-up investigation, excuse me, or was there any further investigation you did later in 2016?
I did.
And what, was that based on what location, or what did you learn in that?
That was on DGB. I learned that Mr. Tetherow at that time was incarcerated in Cumberland County, Tennessee, on bad check charge. In order to interview him, I went to Cumberland County.
This was in summer of 2016? I'm talking about the most recent one. I'm sorry, I should have.
Oh, okay.
Yeah.
You're talking about the Whitwell location?
I am.
Okay. Got some additional information that Tetherow was then operating a online auction from the 13620 Highway 28 Whitwell location. And I was able to develop some Facebook postings and things like that.
On the Facebook postings, who was advertising?
The main advertising was Felicia Tetherow, but Jeremiah Tetherow was posting pictures of merchandise in that time, in that type of information under Capon Tetherow.
So that's the latest. That was the last thing you did in investigating.
That's the last thing, yeah.
Okay. Now, you said you found Facebook postings in that 2016. In your initial investigation, am I right, you found advertisements for auctions in your Facebook posting in the 2015 matter as well, the very first time around? In like 3 separate matters?
Right, yeah.
Did you find advertisements?
There were advertisements for, the initial one was done in 2015 in the Tullahoma location.
Right.
But those advertisements were on a closed Facebook page called Tullahoma Buy Sell Trade.
May I approach the witness, Your Honor?
Yes.
Jasper Trading Post and Auction.
And do you see the various dates? Are there dates that...
31.
Of what year? Okay, so there was an advertisement for an auction auction to take place on July 31st of July of 2000.
Correct. I know there was an August, I believe August 1st, 2015.
Was there a June in 2015?
June 16th, 2015.
And
What are you all looking at, Ms. Ryan?
I don't know the number, Your Honor. It is one of the 2015 investigations. Both 2015 investigations, both 2015 matters contain the
Either going to be Exhibit 2 or 3, members of the commission.
already testified the July 11th, is that correct?
Correct.
So you said July 11th, you said August 14th, is that correct?
August 14th, correct.
Okay. And July 11th, is that
July 11th.
Those are the only ones you remember?
Offhand, yes.
I'll see one advertised for June 20th. And that included that in your documentation as well? Or if you don't recall, that's okay. But do you recall that?
Jasper location.
Yes, at the jail.
Correct, yeah.
Okay. Did you ever have a chance to speak with the respondent, Tutherow?
Did?
What did you learn from Mr. Tutherow in person?
Like I said, I interviewed Mr. Tutherow in the Cumberland County Jail, and initially he denied any knowledge or participation in any of the Jasper Trading or DGB liquidations, but then he said yes, that he did conduct auctions at the 4210 Main Street in Jasper, Tennessee, the Jasper Trading Company, and I gave him the opportunity to produce documentation of those auctions when he alleged that he was selling his own merchandise.
Did he ever admit to calling any of the auctions?
He admitted calling one auction at the 1214 Main Street location in Tullahoma.
But the other auctions, he didn't admit to calling those?
He said he hired one, that he had hired Brent Myers to call auctions at Jasper Trading.
And we just went over the advertisements we saw for the initial location, and then you said, although in September 2016, there were advertisements for auctions at the Whitwell location?
There are advertisements for the Whitwell location
And where were they contained?
in Facebook.
And when you investigated the Whitwell, what did you discover?
That Jeremiah and Felicia Tutherow were operating an online auction, at that location advertising the merchandise on the Facebook pages and accepting online bids, but the winning bidder would have to physically show up at the location to pick up the merchandise.
So there were auctions taking place, albeit online, and advertised by Mr. Totherow?
Both Felicia and Jeremiah Totherow.
Now, earlier than that, prior to the 2015 investigation, and as a part of the 2015 matters, you did the investigation in the spring of 2016, correct?
Correct.
I'm going to show you copies of documents and ask if you can identify these as copies.
Yes, those are my reports.
And they are concerning the 2015 matters, though, right? That's correct?
Correct.
The latest one. So they were follow-up from your initial investigation in the summer of 2015, where you found these other locations.
Correct.
Is this the report that contains the affidavits of Mr. Gully?
Gulley, G-U-L-L-E-Y. Chris?
And also the affidavit of Mr. Totherow, is that correct? He's in.
Yes.
And in his affidavit, he did not,
He-
excuse me?
I think his affidavit was, correct.
And in his affidavit, though, he did not admit to calling any auctions, did he?
No.
But he did tell
He
you-
stated to me that he had called one auction, yeah,
Yeah, he said you called one auction.
yeah.
Did he say anything about the merchandise? I travel from location to location or anything like that?
He didn't give any explanation for that,
Okay.
but it appears to me that it was like a serial attempts at setting up auctions in different locations.
And the last time you talked to him, did he indicate he was going to continue doing any auction? He was in jail the last time you talked to him, is that right?
That's correct.
Well, did he indicate to you whether he was going to continue to do any?
It was his opinion that he wasn't doing anything wrong.
I understand that. Did he say to you whether he was?
He didn't.
He didn't say one way or the other.
No.
Your Honor, this I would like to enter as. There are two separate reports containing basically information.
The one dated March the 2nd of 2016, and the paralegals corrected the number at the end to be 2015-0220861, will be marked and entered into evidence as exhibit number 5. If you'll hand this one to the court reporter, please. One dated April the 1st of 2016 will be marked and entered into evidence as exhibit number 6. You'll pass that to the court reporter, please, and you may pass copies to the commission.
Now, in the fall of 2016, when you found the Facebook page, you did not submit a total separate investigative report, is that correct?
That's correct.
But you were included in part of the investigation, and that's how you determined that things were still going on at this last location you spoke of, right?
But well, location.
That was the online auction location?
Yes.
Okay. Have you had any occasion to investigate since that time?
No.
And you haven't heard anything more about or from Mr. Totherow since the fall of 2016? I have nothing further for this witness, Your Honor.
Thank you, Ms. Ryan. Members of the panel, do you recall all have any questions for Ms. Wilson Weaver?
Don't mind, Mr. Chairman.
Let me hand her copies of the exhibits you all just got. There you go.
I appreciate you being here today and testifying before our committee for this hearing today. I'm just trying to get a clear understanding of everything you talked about. When you talked to Mr. Tutherode, and you said that he finally did admit that he did do some of the auctions, or
He stated to me that he had called one auction at the Tullahoma location.
Okay.
That's all he admitted to.
all right, just the one auction.
Correct.
All right. And he had hired auctioneers for other auctions. Did he admit to doing that? All right. I just read the statement by Mr. Myers, and he said he called one auction according to his statement, and that in the middle of the second auction, during a break, he asked Mr. Tutherode, did he have a license? He confirmed about it, and then Mr. Tutherode said he didn't need a license, and so he quit the auction and stopped at that point in time. Is that your understanding?
Correct.
Okay. Of the items that were being sold, did you have any knowledge, or did you ever figure out where did the items come from?
Based on my investigation, some of the items, I don't know about all of them, but some of the items were purchased from a location in Crossville, Tennessee. And these items were pallet loads of merchandise from places like Walmart or Sears. And I could not determine, there were a considerable amount of merchandise in the Jasper Trading Company location. But I had no way of determining if those items were in fact what was purchased from.
Based on your general knowledge of this case, were there any public consigners? Were there any individual consigners that were saying, here, would you sell my individual items? Were there any consignments of that nature?
I could not find any, no.
Okay, so as far as you know, these were items that were bought in bulk and then broken up and sold as individual pieces?
Correct.
Okay. Do you know if Tutherode purchased those items, or were there anybody else that bought the items that were sold?
The only incident that I know of was when he purchased items in Crossville.
Okay.
I spoke with the company owner that indicated that Mr. Tutherode had bought pallet loads of merchandise.
So these were basically new items that were return items or over inventory items, but there were no used items or used equipment or of that nature?
Correct.
Okay.
Some of the items were damaged items from return pallets, correct?
That's what I understand that,
I was looking at the company that here at the warehouse one, and I think that's what they sell. A lot of it comes back damaged. They just sell it by the pallet. Some of it's
Damaged,
new,
returned.
overstock, or what
Correct.
have you. So, but Mr. Tutherode was buying from that company in Crossville, for your understanding.
And Chris Gully's involvement, was he ever an auctioneer? Did he ever call any auctions during these cases?
Misty Meeks, when I interviewed her, gave me his name, that he had called auctions at that location. But when I interviewed Chris Gully, he indicated that his only participation was to provide sound equipment because Tutherode's equipment didn't work. But he admitted attending several of the auctions.
Questions I have, Mr. Chairman.
I have nothing.
No other questions by the commission?
No.
Ms. Ryan, any other questions for Ms. Wilson Weaver?
Follow-up. Did you include that information about the pallets and things in your investigation, or that's just something you learned through the investigation, where the purchases were made and all of
That was part of the I learned that they were
Okay,
made.
and did you include any sales documents or anything to show that those purchases were made from any particular company?
Warehouse 1 in Cookeville.
That's the only one, okay.
Yes.
Now, you talked earlier about a bad check. Can you tell me about that bad check?
When Mr. Tutherow purchased those items from Warehouse 1, he paid for them with a $5,000 bad check.
That's the reason he was in jail when you found him.
And there was a warrant, well, there were two reasons. Parole violation on another charge and the check charge out of Cumberland County. But
Do you have any idea whether that has ever been resolved?
I'm assuming that it's been resolved since he was out of jail when he was served with the, but I didn't follow up to see what the,
Okay, so you don't know?
no.
Thank you. I have nothing further for this witness.
Thank you, Ms. Ryan. Members of the commission, any other questions for Ms. Wilson Weaver? Thank you, ma'am.
That concludes the state's proof, Your Honor.
Members of the board, why don't we take about a 5-minute break, and then I will give you your charge, and we'll start deliberations. All right, please do not discuss the case amongst yourselves during the break. Ryan, did you want to make a closing argument?
Yes, Your Honor, I would.
All right, go ahead.
Thank you. These are two respondents, Jeremiah Tutherow, Jasper Trading House. We have Jasper Trading House as a named respondent absolutely in the 2015 investigation. It is the name on the Facebook pages for various auctions. We know about another company at some point, and that would be in 2016, we learned, or 2016, we learned of DGB liquidations, but they are not responding here, but DGB appears still to be Mr. Jethro Tutherow. What we know for sure is that in Tullahoma, where this started, there was an auction. In the main street in Jasper, as you heard, there was an auction. In Dunlap, there was an auction. And in Whitwell, there was an auction. That is what we know. We know that Mr. Tutherow had gone from place to place and had a different business depending on where he was conducting auctions. We know that he purchased property from a company, purchased it, and then attempted to sell the property when he was in jail on a bad check charge. Do we know if he personally owned the property? I have no idea. Do we know that Jasper Trading House was offering some of the property? We do. Do we know that Jeremiah Tutherow called at least one auction? We do. Do we know who called the rest of the auctions? We don't. We know that Mr. Myers said he only did one. What we have here is an individual who apparently had been making a practice of going from location to location to location to attempt to do unlicensed auctioneer work. He had an opportunity to come today to present his side of the story, and if indeed he had owned the property and was just simply ignorant, he could have presented that to you, but he did not. I'm suggesting then that there are 4 absolute separate locations that we can find there were auctions. That is Tullahoma, Main Street in Jasper, Dunlap, and Whitwell. And that these are the 4 locations that we should find that these respondents held auctions. The very first location we know for sure was was Jasper Trading House. I cannot say that Jasper Trading House was doing the other 3, but I can say that Jeremiah Tutherow was doing the other 3. I'm asking for civil penalty of $1,000 for the Tullahoma location, for both Mr. Tutherow and Jasper Trading House, $1,000 for the Main Street location, $1,000 for the Dunlap location, and $1,000 for the Whit location as unlicensed activity, and that he be required to pay all court costs in this matter. That includes and is not limited to the court reporter's fee, the judge's fees, and other matters. It could include the investigation fee as well. Thank you.
Thank you, Ms. Ryan.
I have proposed finding of facts and conclusions of law.
Let me wait and give the charge first. Thank you. Members of the commission, you have now heard the state's proof in the case of the Department of Commerce and Insurance versus Jeremiah Tutherow and Jeremiah Tutherow, DBA Jasper Trading House and Auction. It is now my duty to charge you as to the law you must follow in reaching your decision. You are the exclusive judges of the facts in this case. You also are the exclusive judges of the law, specifically your statutes, rules, and regulations. and their application to this case. You should apply the law to the facts in deciding this case under the directions of my charge. You exclusively have the authority to make findings of fact and reach conclusions of law in this matter. No one else can participate in your deliberations. However, if you find that you need to have the law or legal terminology explained to you, I can assist you. The state has alleged that the respondents have violated certain of the state's applicable statutes and rules. It is the state's burden to prove those allegations by a preponderance of the evidence. Do not confuse this standard with the higher standard of beyond a reasonable doubt, which is used in criminal court proceedings. A preponderance of the evidence means the greater weight of the evidence, or that there is sufficient proven information to cause you to believe that the state's allegations provide the more probable conclusion based upon all of the evidence that has been presented. You must limit your inquiry into violations of rules and statutes to those that were specifically alleged in the state's notice of charges. That document, the notice of hearing and charges, was handed to you at the beginning of these proceedings. And you must base your determination solely on the evidence presented to you during today's hearing. The evidence consists of the testimony given by the witnesses during the hearing and the exhibits that were entered into evidence during the hearing. You may review the exhibits during your deliberations. Statements by attorneys in the case and the documents that are contained in the technical records, such as the notice of charges and the proposed order that Ms. Ryan is going to pass to you at the conclusion of my charge, are not considered evidence in the case. You may use these documents to assist you in making your findings of fact and conclusions of law, but you should do so only after careful consideration and a determination that they accurately reflect your own independent recollection of the evidence and your own conclusions from the evidence. You must make your findings of fact based solely on the evidence presented to you during the hearing. There are two kinds of evidence, direct and circumstantial. Direct evidence is direct proof of a fact, such as testimony of a witness about what the witness personally observed. Circumstantial evidence is indirect evidence that gives you clues about what happened. Circumstantial evidence is proof of a fact or a group of facts that cause you to conclude that another fact exists. It is for you to decide whether a fact has been proved by circumstantial evidence. If you base your decision upon circumstantial evidence, you must be convinced that the conclusion you reach is more probable than any other explanation. You are to consider both direct and circumstantial evidence. The law permits you to give equal weight to both, but it is for you to decide how much weight to give any evidence. In making your decision, you must consider all of the evidence in light of reason, experience, and common sense. The state has charged that the respondents have violated certain of the state's applicable statutes and rules. For each of these charges, you must determine whether the alleged violation has been proven by a preponderance of the evidence and specify in the findings of fact portion of your order the specific underlying facts that support your decision. In making your determinations, it may be necessary for you to interpret your statutes and your rules. When the language of the statute or rule is plain, then you must follow the plain meaning of that language. However, if the language is ambiguous, you may give your interpretation of that language so as to explain the conclusion you reach as to the violation charged. Although you may only consider the competent evidence presented during the hearing in making your decisions, this does not mean that you are required to set aside your knowledge or expertise in your field. You may and in fact should weigh the evidence in light of your training and your own observations and experiences. You should always keep in mind that the state bears the burden of proving the charges. The respondent does not have the burden of proving that he is innocent. The Administrative Procedures Act specifically requires that your final order contain 4 sections. Number 1, findings of fact. Number 2, conclusions of law. Number 3, a decision regarding what disciplinary action shall be taken, if any. And number 4, the policy reasons for your decision and determination. In making findings of fact, you must make your own evaluation of the testimony given by each of the witnesses and any documentary evidence admitted. You must then give that testimony or other evidence the weight and credibility that you deem proper. You may weigh the evidence in light of your own training and expertise. Once you have made your findings of fact, you must decide if the respondent's activity constitutes a violation of departmental or board rules or state statutes as alleged in the notice of hearing and charges. And if so, you must state those determinations in the conclusions of law portion of your order. Your decision must include sufficient analysis of the evidence to clearly demonstrate how the facts of the case support your conclusions of law. Your conclusions of law should make appropriate, specific references to your findings of fact to articulate linkages and connections between the two sections of your final order. If you decide that there has been a violation of a state statute or rule, you must then decide what disciplinary action is appropriate in accordance with your legal authority and considering the particular circumstances of this case. You may consider any evidence that the parties have introduced on the issue of the appropriate disciplinary action, including whether the conduct allegedly was or is of a continuing nature or a one-time offense. Additionally, you may also consider what you have done in previous similar cases. Under the law, administrative agencies are not required to have absolute consistency in the disciplinary actions that they take. However, this does not mean that you may be arbitrary and capricious in dealing out disciplinary actions. Disciplinary actions must be based on fairness and reason. Finally, a policy reason must accompany your determination to state why the decision you render in this situation is appropriate. Your policy reason is your statement explaining why the particular disciplinary action you chose in this case is correct given the wide range of cases you hear and the various disciplinary options you have. Your deliberations must be in public before all parties that are present for today's hearing. If you need assistance with the law or the structure of your order, I will be available to assist you. Any action taken by the Commission must pass by a majority vote of today's panel. If you have any questions about the facts presented, you may, by a majority vote, reopen the proof and hear further testimony from witnesses and or argument from counsel. Brian, you have a proposed order?
I have proposed finding of facts and conclusion of law, yes, Your Honor.
Okay, if you'll pass that up, please. Members of the board, I'm going to add this document to the technical record as technical record entry number 5. And the copies will now be passed to you. This is a proposed draft of the findings of fact and conclusions of law section of your order. This time, I will, unless you all have questions for me about the charge, I will turn it over to Chairman Thorpe to preside over the deliberations.
Thank you, Your Honor. Minutes to look over this.
And members of the commission, Ms. Ryan will prepare the order for the chair's signature once you all have developed the order. She will also include in that order a section regarding the default. If the board votes for you all to reopen the record to ask counsel a question, you may.
I would like to ask additional questions of counsel if the board would agree to reopen. Trying to sort out, because there's a lot of hit and miss here. We are looking at 4 separate different auctions.
That's correct.
Can you recite the dates of those auctions?
I can't recite the exact dates. I can recite that the investigation showed that an auction took place in 2015 in Tullahoma, that auctions
The
took...
month even?
We don't have any proof of the month.
Okay.
That auctions took place, that there were advertisements for auctions for Jasper, Tennessee, on July 18th, July 11th, and July 20th. That there was an investigation in Dunlap, and that there is a date that was observed an auction in Dunlap of February 20th, 2016. That in September of 2017, at the Whitwell site, there were advertisements for auctions, but not a date.
Okay. Thank you.
Any other questions for counsel? And any other proof the board would like to hear?
No, Your Honor.
All right, the record's closed again, and Mr. Chairman, the deliberations are turned back over to you.
Thank you, Your Honor. Looks to me like there's 8 separate violations. 4 for auctions and 4 for no gallery.
Got a question for counsel?
This is a discussion that we're having.
Discussion here.
among ourselves.
Okay,
We're
go ahead.
we have to come up with our findings of fact at this point. If you might, Mr. Chairman, let me move for the following findings of fact, if you don't mind.
Okay.
Number 1, I think the state has proved that Jeremiah Tothrow, the respondent, is not licensed, has never been licensed with the Tennessee Auctioneer Commission, and was not licensed at the time of these findings. Number 2, that Jasper Trading House and Auction is not licensed and has not been licensed with the Tennessee Auctioneer Commission, and was not licensed at the time of these findings. Did hear from the investigator who visited these sites, and the investigator did find advertisements for auctions in July, on the 11th and the 18th of 2015, and also on June 20th of 2015 on a Facebook page under the trade name Jasper Trading Post and Auction.
Mr. Marsh?
Yes.
It might be simpler to do them in parts, because your first 2 findings are essentially the 2 first proposed findings, and then you're combining some others. So if you want to go ahead and see if the commission agrees with you on findings 1 and 2,
Okay.
that might help with making a clearer record as to where you all are going with your actual order.
All right, well, I would make the 1 and 2 then as the first 2 findings of fact.
Commissioner Morris moves findings 1 and 2.
Second.
Second by Commissioner Lewis. All in favor say aye.
Aye.
Opposed, nay. Let the record show all 3 members present voted in favor.
Trying to, without reading this entire document, a way to, maybe make this a little bit more concise. I think the state has proved its case through the investigation and through the other materials that they have provided us today, that Tetherow was buying items for the purpose of resale through the auction method, and then he held at least 4 separate auctions that we know about, not counting the ones we don't know about, and that he admitted to doing so. That would be a finding of fact.
Would you like to state that, how you would like it to be read in the order?
I move that we find that Mr. Tetherow, in the name of Jasper Trading House Auction, held at least 4 separate auctions of property that he purchased for resale, which is a violation of our statute.
Again, this is, as I explained in the charge, if you'll limit this section to facts,
Okay.
we will get to conclusions of law and violations later.
Okay.
But you've got to have your factual portion of your order before you make your conclusions of law.
Okay. Well, he held 4 separate auctions selling items that he purchased for resale.
Can I ask a question? Jeff, you might know. If we agree with these findings of fact, can we not just accept them as they are, or does it have to be entered in the record verbally?
Makes a much cleaner record if you'll read each one, so that way you know what you're specifically approving.
Would it need to be read into the record verbally?
Yes.
It's preferable. Again, consider what you're doing. You're making a record of your hearing. The court reporter is writing down what you all are doing. So for someone to come back and review the record later, it's much better for you all to be specific as with regard to what your findings are, as opposed to simply, we accept something. So do you want to reread, Mr. Morris, the finding of fact number 3 you've just proposed?
Yeah, I'll be glad to do that. That would make it, I think, a lot cleaner and easier. Make that in the form of a motion, Your Honor. All right, so I'll move that the investigation took place in July of 2015, and in that investigation, investigator Lori Wilson Weaver traveled to Lahoma, Tennessee, and found that the location at least one auction had taken place, and that Jeremiah Tetherow and Jasper Trading House were the parties responsible for that auction. Number 4, that the investigator learned through an employee, Misty Meeks, that Miss Meeks had worked more than one auction for the respondents, and that those auctions took place also in Jasper, Tennessee, and that she provided an affidavit to that point. Number 5, Ms. Meeks also told the investigator there was a person who did the auctions who was a licensee, but that person quit after the respondent, Tetherow, did auctions but hired an unlicensed person, Chris Guller, to do the auctions. Investigator number 6, Investigator Wilson Weaver also met with Chris Guller, who stated that he provided sound equipment, and in a later meeting stated that he attended auctions where the respondent called the auctions. That's an important point. 7, that respondents Brent Myers did have a license to call the auctions, but Mr. Myers quit after learning that respondents held no license.
Okay, so number 7 is not phrased the same way as what was proposed.
Right, but in other words, respondents did that. The respondents had a licensee,
Right. Okay.
Brent Myers, to call the auction, but he quit after learning that they held no license. Number 8, in the investigation, Investigator Wilson Weaver found the advertisements for auctions on July 18th, July 11th, and June 20th, 2015 on a Facebook page under Jasper Trading Post and Auction. Number 9, in a later investigation, Investigator Wilson Weaver traveled to Dunlap, Tennessee, where a new location was being operated by respondent Tetherow under the name DGB Liquidations. At that location, Investigator Wilson Weaver learned that the auctions were also being held by respondent Tetherow. Number 10, Investigator Wilson Weaver attempted to contact respondent Tetherow in Dunlap and discovered that respondent Tetherow was in Sequatchie. How do you say that? Sequatchie? Sequatchie County Jail, awaiting transfer to Cumberland and Campbell counties. And then while in Dunlap, number 11, while in Dunlap on February 20th, investigator Wilson Weaver observed an auction advertised and cars in the parking lot and people in the building. 12, investigator visited Respondent Tutherrow in jail, and Respondent Tutherrow initially denied any operation of any unlicensed auction gallery, stating that Brett Meyer was the auctioneer. Respondent Tutherrow also asserted he could sell his own property, but admitted he had called one auction at the Tullahoma auction location, but did not admit his guilt. It did not admit this in the affidavit he signed. Number 13, in February of 2016, investigator Wilson Weaver found operations for a respondent for Whitwell, Tennessee. At that site, the bidders were solicited online but had to appear at the physical location to secure the merchandise. Number 14, Facebook page again advertised auctions over September the 17th, 2016 at the Whitwell site, and pictures of the items to be auctioned were posted by respondent using respondent's middle name. And number 15, respondent declined to provide any documents concerning all of these auctions and could not show that he individually owned the property auctioned.
Second.
Commissioner Morris moves. Commissioner Lewis seconds. Further discussion? All in favor say aye.
Aye.
Opposed, nay. Let the record show all three members voted in favor of that motion.
At this point, you'd want to decide if there are any additional facts you would like to find other than what's included in the proposal from the state's attorney.
The only other finding of fact that we talked about that we didn't list here in these findings is the fact that these items were purchased in bulk and then broken up to be resold as his own property, but
How would you specifically like that to be worded?
I really don't know. That the state showed, or the testimony of the investigator was that the items that were being sold were purchased in bulk from a supplier and then resold at auction.
Morris moves that we add 16. The testimony of the investigator showed that items were being sold in bulk, or bought in bulk, to be sold individualized, or something that sounds similar. There's a second to that.
Second.
It's been properly seconded. Any other discussion? All in favor say aye. Any opposed, nay. Let the record show all three members present vote in favor.
Okay, so we can either get the court reporter to read back what Mr. Morris said, or Mr. Thorpe, you can read it again, but what you said wasn't exactly what he said, and Ms. Ryan has to make an order that's in writing of what you all want as finding of fact number 16. Would y'all like to have the court reporter read back what Mr. Morris said originally?
Yeah, that'd be great.
It sounded better.
that what you all want?
That's fine.
Okay. If I were you, Mr. Chairman, I would just vote on that language specifically your vote earlier was just unclear as to what you all were voting on.
We had a motion and a second, the language that was just presented by the clerk. Now let's vote on it. All in favor of that, please say aye.
Aye.
Any opposed? The record show all three members vote in favor of that. Your Honor.
And then at this time, if there are no other facts you all would like to add after number 16, you would want to move to the conclusions of law portion of your deliberations.
I think we can go ahead and make a motion to that effect, if you would, Mr. Chairman. I think then I think the state has proved that the conclusions of the law are that, number one, that the respondent's acts and conduct as described in our findings of fact constitute a violation of the Tennessee Code 6219-102A1 that states it is unlawful for any person to act or advertise or represent to be an auctioneer, apprentice auctioneer, or firm without holding a valid license issued by the Commission under this chapter or prior state law. And number two, that the respondent's act and conduct in the foregoing findings of fact constitute a violation of Tennessee Code 6219A. Said any person who desires to own or operate an auction house, auction barn, auction gallery, or any other type of auction operating at a fixed site for the purpose of selling consigned or purchased goods at a fixed location is required to first obtain a gallery license. If the gallery license holder operates more than one auction, the licensee shall be required to obtain a branch license for each permanent location and pay the appropriate fee. If the auction house, auction barn, or auction gallery is owned or operated by a licensed auctioneer holding a valid firm license, no further license shall be required.
Second.
Commissioner Morris moves. Commissioner Lewis seconds. Any further discussion on this? All in favor, let me know by saying aye.
Aye.
Any opposed? Let the record show all three members vote in favor of that motion.
Our decision would be next, is that correct?
Yes.
Based on the findings of fact and the conclusion of law, I make a motion that we find that the defendant, Jasper Trading House and Auction, and Mr. Jeremiah Tuthrow are in violation of the law on at least 4 separate occasions, and that we fine the defendant, Jeremiah Tuthrow, and Jasper Trading House out and Auction $1,000 each for the 4 violations, plus the cost of this administrative hearing.
Second.
Motion's been made by Commissioner Morris to fine a violation of $1,000 each for 4 accounts plus administrative hearing cost. And it's been properly seconded by Commissioner Lewis. I do have a question. I did see somewhere in here that we could do up to the $2,500.
We could.
Is that
This would be a total of about $8,000 plus the cost, as you're probably looking around $10,000 fine total. Us maybe making it a little bit more. We could probably try that. It's just collecting's going to be tough.
Can you make sure your mic's working, Commissioner?
Yes. I don't disagree that it would be tough to find, but to collect, but this is very serious charges. I mean, this is an individual, it looks to me, who has danced around dodging people, for quite some time, and no, I just think that's a little light. That's just my opinion.
increased it to the $2,500 per charge. It would be $20,000 plus cost. If that's something you'd be more inclined to do, I'd make that in the form of a motion.
I would.
Okay. I would like to revise my motion.
Commissioner Marsh?
Yes.
Will you make sure when you rephrase it that you clarify that you are intending to find 4 violations for each respondent? I think it might be helpful to do a finding for the first respondent and
All
a
right.
finding for the second respondent,
All right.
so that we know that our math all
Since we
adds up.
have 2 different defendants in the case, I make the motion that we find Jeremiah Tuthero 4 counts of holding illegal auction at $2,500 per count, plus the cost of this hearing. And we also find against Jasper Trading House and Auction 4 counts at $2,500 each, which would make a total of $20,000 plus the cost of this hearing.
Second.
Motion's been made and properly seconded. Further discussion? All in favor, let it be known by saying aye.
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 All opposed, nay. Let the record show all 3 members voted in favor of that motion. Thank you, Commissioner.
Mr. Chairman, and the judge would now issue a policy reason, I guess, for our decision.
Yes.
I would move that we read this into the record as a policy reason for the findings of this administrative hearing, that it is the policy of this commission to uphold the state statutes regarding the scope of this commission in order to protect the consumers who are involved in the purchase and sale of real and personal property in the state of Tennessee.
Second.
Motion's been made and properly seconded. Any discussion? All in favor say aye.
Aye.
Any opposed, nay. Let the record show all 3 members present voted in favor. Your Honor.
Thank you, members of the commission. Ms. Ryan, if you would draw up the order for the chair's signature, and if you would make sure and include the default finding that happened at the outset of the hearing. Once that is filed in my office, that will be considered a final order under the Tennessee Administrative Procedures Act.
Thank you, Your Honor.
Thank you all. We will stand adjourned from the hearing. Mr. Kopchak, I'll turn your board back over to you for the rest of your meeting. Thank you.
Chairman, if we may just
Brian.
take 5 minutes to just take a break so we can allow everyone to kind of clear out and resettle.
Yes, sir.
Thank you.
Be back in 5 minutes. No objection.
The rest of it won't take long.
All right. We're back to our regular order for the legal report.
Morning. I've only got 2 complaints today to present to you. Would you like me to read them verbatim or just paraphrase them for you? I can paraphrase it if you'd like.
The first one, you definitely need to
I
paraphrase.
figured, okay. So number 1 is 2017-051-641, and I'll do my best to paraphrase. The complainant originally submitted this complaint to Consumer Affairs. They felt it was not within their jurisdiction, so they forwarded it to the Auctioneer Commission. And the complainant states that he purchased an item for $275 from respondent's auction website. He won that item. He got the confirmation email that he won the item. He also purchased, he said, multiple other items that same day. So on the confirmation email, once he paid that $275, they prompted him to choose how he was going to obtain the items that he bought. So all of the items happened to be located at a warehouse per respondent's confirmation email, and he was going to be picking them up on a specific day, all of them. And it happened that this one item referenced in the complaint was mislisted as being at the warehouse, when in reality it was with the seller of the item, and he was to pick it up at their house, which was in, it was not that far away, but it was not at the same warehouse. Complainant had hired a driver to pick up all of these items, and so he was upset about that, and he called and talked to a representative from the respondent's company, and they asked him what he would like to do, if he wanted a refund or if he wanted to pick it up a different day. They were willing to let him pick it up the next day, or any day after that. And he said, well, I've hired this driver, I need to talk to my wife and talk about our options, I'll call you back. In the complaint, it states that he did not say he wanted a refund, that he called back within 10 minutes and said that he wanted to get the item and he would pick it up. And at that point, the representative said that the item had already been refunded. He could check his account. They already refunded it, and the seller did not want to sell it. That is the complainant's story. The respondent's representative, who spoke to the complainant that day, states that that's not how it happened, that he told them that, yes, I've hired a driver, I'm upset about this, I want a refund. So they issued the refund right away. They state that, yes, he did call back, but it was more like an hour later. And the wife also called and said, we want to pick up the item the next day, which was a Saturday, and they told her, that we've already made the refund, I'm sorry, the seller doesn't want to sell it at this point, and that's basically the gist of the complaint. So I don't have any proof. I emailed the complainant and asked them to give me some proof or any kind of evidence that the respondent did anything wrong. I understand that it was...
Yeah, I read the complaint.
Okay.
I didn't see anything in there. This is just one of those things that, the auctioneer should have been more clear where the item was to be picked up, when it could be picked up, and we all... It was just human error.
Yes.
And it was not any intent of a violation of law. I didn't find any violation of law. Your recommendation is to dismiss this complaint, and I would recommend that we follow your advice on this particular matter, and I move that we dismiss the complaint.
Second.
Mr. Morris moves. We concur with council's recommendation. Mr. Lewis seconds. Any discussion? All in favor say aye.
Aye.
Any opposed, nay. The record show all three members vote in favor of that. Council.
Number 2, 2017-050-521. An anonymous complaint was received on August 2nd, 2017 from a concerned citizen stating that respondent appeared to be conducting real estate and gun auctions despite having an expired license. Complainant attached copies of advertisements as follows. The first was an advertisement for an absolute estate auction on June 15th, 2017. The second is an advertisement for an absolute gun, ammo, gold, diamond jewelry, and coins auction on June 24th, 2017. And the third was an advertisement for an estate auction on August 12th, 2017. Our department also sent a copy of the complaint to the Real Estate Commission for investigation on or around August 2nd, 2017. Respondent responded to the complaint on August 4th, 2017, and stated that as soon as he received the complaint the day before, he contacted our licensing division about his expired firm license. Respondent states that he has been licensed as an auctioneer since 1990, has never had an issue like this or any issue with his license before. He did not realize his firm license was expired until he received the complaint. Respondent states that it was an oversight on his part. He immediately filled out the renewal application. He paid all fees due. The respondent's license was reinstated, and he also states that he understands it's not his responsibility, or it is his responsibility to keep up with the licensing requirements, even though he never got a notification that it was expired until this complaint was received. I emailed with him and I asked him to, be as forthcoming as he could, and I said, have you ever let your license expire before? And he said no, and I couldn't find that he had. I said, are you sure you didn't receive notification that your license was expired before this complaint? And he promised me that he did not. I didn't see anything in the records. And because he's never had an issue before, because he took care of it literally like within 24 hours, my recommendation is a letter of warning for unlicensed activity.
Question is, he had an individual auctioneer's license and a firm license.
Yes.
The only license that expired was the firm.
Yes.
So his individual auctioneer license was still valid.
Yes.
During his term.
Yes.
Okay. Well, I would agree with you. We seem to be having some issue with the notices getting to everybody. This is not the first time I've heard of it. And so I would recommend that we go along with writing a letter. And I don't think the guy had any intention of being in violation of the law at all.
He was very honest with me and talking with me and very forthcoming, and I do believe that it will not happen again.
Second.
Commissioner Morris moves we concur with council's recommendation and send a letter of warning for unlicensed activity. Commissioner Lewis seconds. All in favor, say aye.
Aye.
Any opposed? Is that all for you, council?
That is.
Thank you.
Easy. There you go.
Thank you very much.
Thank you.
I do think it's important, and Glenn hit on this earlier, we have no statutory or regulatory requirement to send notice of license renewal. So it is a courtesy. It's been a big respondent issue that they're coming back and saying, well, you didn't send me notice, so
Right.
it's not my fault. I don't get notice when my license expires, so.
And I go to my license cabinet every month and make sure nobody in my firm has got one coming up. So I'm very sensitive to it. I've got about 16 different licenses, you know, all the different states and firms.
I mean, y'all are required to keep them like,
I know,
you know,
it's tough.
posted, so you would think when you walked by it and you said,
It's tough, yeah. You're right. You know, you know, you got to pay attention to those things. Yeah, we had a newsletter. We could send them a notice. It'd be
we're looking. We're going to try to figure it out.
I think the newsletter thing is sort of a sore spot with me. Other states do a really good job with their newsletters, and Tennessee does nothing, and it makes us look bad. That's my only point.
Do you have any new business, or did you want to move to adjourn?
Does anybody have any new business?
Go ahead, Adam, move it.
No new business, moved to adjourn.
Second.
Adam moves. Jeff seconds. All in favor, go home.
Good job, Chairman. Thanks, guys.